Most people know that consumer protection laws exist, and that businesses are not allowed to just do whatever they want in a consumer transaction, but many of us are unaware of what those laws actually say. In Ontario, one of the many types of laws that relate to this topic is called the Consumer Protection Act. This is a relatively long document, but for the purposes of this video, we're going to be taking a quick look at the unfair practices part of the Act, which is found at Part 3 and includes sections 14 to 19. I'm Ryan Keeney, and I'm a lawyer in Ontario. Let's get into it. Before we get into what the Consumer Protection Act doesn't allow, remember that this act doesn't apply to all types of businesses. So be sure to watch my other video about what businesses are not required to follow the Consumer Protection Act. Fortunately, those other types of businesses have their own laws that they have to follow, so consumers still have at least some protection in those other industries. All right, so starting with Section 14 of the Act, this section says that it is an unfair practice for a person to make a false, misleading, or deceptive representation. But that seems like a pretty vague statement, right? After all, we need to know what type of behavior constitutes a false, misleading, or deceptive representation. Fortunately, Section 14 goes on to give us 17 examples of this. Any of the following representations made by a business would be considered false, misleading, or deceptive. 1. That the goods or services have sponsorship, approval, performance characteristics, accessories, uses, ingredients, benefits, or qualities they do not have. 2. That the person who is to supply the goods or services has sponsorship, approval, status, affiliation, or connection the person does not have. 3. That the goods or services are of a particular standard, quality, grade, style, or model if they are not. 4. That the goods are new or unused if they are not or are reconditioned or reclaimed, but the reasonable use of goods to enable the person to service, prepare, test, and deliver the goods does not result in the goods being deemed to be used for the purposes of this paragraph. 5. That the goods have been used to an extent that is materially different from the fact. 6. That the goods or services are available for a reason that does not exist. 7. That the goods or services have been supplied in accordance with a previous representation, if they have not. 8. That the goods or services or any part of them are available or can be delivered or performed when the person making the representation knows or ought to know they are not available or cannot be delivered or performed. 9. That the goods or services or any part of them will be available or can be delivered or performed by a specified time when the person making the representation knows or ought to know they will not be available or cannot be delivered or performed by the specified time. 10. That a service, part, replacement, or repair is needed or advisable if it is not. 11. That a specific price advantage exists if it does not. 12. That misrepresents the authority of a salesperson, representative, employee, or agent to negotiate the final terms of the agreement. 13. That the transaction involves or does not involve rights, remedies, or obligations if the representation is false, misleading, or deceptive. 14. That using exaggeration, innuendo, or ambiguity as to a material fact or failing to state a material fact if such use or failure deceives or tends to deceive. 15. That misrepresents the purpose or intent of any solicitation of or any communication with a consumer. 16. That misrepresents the purpose of any charge or proposed charge. 17. That misrepresents or exaggerates the benefits that are likely to flow to a consumer if the consumer helps a person obtain new or potential customers. With that list out of the way, consumers will be glad to know that there are even more protections in the remaining sections. Section 15 goes on to say that it is an unfair practice to make an unconscionable representation. But what constitutes an unconscionable representation? Fortunately for consumers, Section 15 leaves the answer to this question very open-ended, but it does provide us with a list of 8 things about any given situation which could be taken into account when deciding whether or not an unconscionable representation has been made. These include situations where the person who is making the representation to the consumer knows or should have known any of the following things. 1. That the consumer is not reasonably able to protect his or her interests because of disability, ignorance, illiteracy, inability to understand the language of an agreement, or similar factors. 2. That the price grossly exceeds the price at which similar goods or services are readily available to like consumers. 3. That the consumer is unable to receive a substantial benefit from the subject matter of the representation. 4. That there is no reasonable probability of payment of the obligation in full by the consumer. 5. That the consumer transaction is excessively one-sided in favor of someone other than the consumer. 6. That the terms of the consumer transaction are so adverse to the consumer as to be inequitable. 7. That a statement of opinion is misleading and the consumer is likely to rely on it to his or her detriment. Or 8. That the consumer is being subjected to undue pressure pressure to enter into a consumer transaction. That's a pretty decent list, and it provides a lot of general protection to consumers. Moreover, it doesn't just apply to the person who is actually talking to the consumer. Let's say a salesperson or some other individual makes an unconscionable representation to a consumer. In that situation, if that individual's employer knew or should have known that any of the previous 8 things I mentioned were applicable, then the employer can also be held responsible as well. Now, Section 16 goes on to say that it is an unfair practice for a person to use his, her, or its custody or control of a consumer's goods to pressure the consumer into renegotiating the terms of a consumer transaction. As you can imagine, this law is pretty important. Imagine a situation where a business just holds your property hostage to get you to change the deal. Of course, there are some laws under another law in Ontario called the Repair and Storage Liens Act, which sets certain boundaries regarding that topic. But for the most part, Section 16 provides a lot of protection to customers. Moving on to Section 17, since everything in the law needs to be spelled out even when it's obvious, Section 17 simply says that no person shall engage in an unfair practice, and that a person who performs one act referred to in Section 14, 15, or 16 shall be deemed to be engaging in an unfair practice. There is an exception, though, because this section also says that it is not an unfair practice for a person, on behalf of another person, to print, publish, distribute, broadcast, or telecast a representation that the person accepted in good faith for printing, publishing, distributing, broadcasting, or telecasting in the ordinary course of business. In other words, if someone reproduces something they think is true, which they learned from another source, and they do this in good faith, then they haven't violated Section 17. To keep things brief, I'm going to wrap this video up at that. But I will say that Section 18 goes on to provide some exciting solutions for consumers in terms of voiding contracts where an unfair practice might have occurred, as well as their rights to seek compensation. But I'll leave that for another video. If you'd like to learn more about that, simply leave a comment requesting it, and I'll put together a video about Section 18. I'm Ryan Keeney, and I'll see you next time.